welcome to the second webinar of a pre-recorded series for Stewart Title. My name is Ian Quayle and welcome. And what we're going to be doing today is looking at some issues with regard to acting for a buyer. And I've called this webinar 10 Good Habits. Of course, there are 10 good habits, but there are a lot more that we'll be exploring as we progress in connection with today's presentation. It'll last about 60 minutes. If there are any questions or queries relating to anything that I've said, or you want clarification or amplification, feel free to contact Stewart Title, and they no doubt will contact me, and I'll endeavour to assist. So, as I mentioned, we're talking about acting for the buyer. We're at the start of the conveyancing process, and what we've got to do is ensure that we deal with some very important issues in connection with the conveyancing process when acting for a buyer, and also taking into account the fact we could also be acting for a lender. So, lots of things to talk about, so we'll start, if we can, acting for the buyer and taking instructions. A very, very important point here about onboarding clients and making sure that we verify client identity, making sure that as far as the client is concerned, we're setting realistic client expectation. We're explaining to the client the conveyancing process so that the client has an overview of what we're going to do. And then what we're going to do is personalize those steps and processes as the transaction progresses. So if we talk about verifying client identity to start with, the important point here is that we cannot assume that verification of client identity at the start is sort of a one-hit, one-shot, and then we can close the book and not have to worry about client identity going forward. To avoid or prevent property fraud, it is absolutely essential that when we're onboarding clients, we're careful about ensuring that we do the appropriate checks to verify identity. And through the life of the transaction, we are constantly aware of the fact that there could be information that is shared with us that reveals issues associated with our client identity, mortgage fraud or other fraud. So as far as that is concerned, we might use an electronic verification system, in which case it is essential that we comply with the process that our electronic verification provider requires of us. If we're using what I would class as the old-fashioned system of client verification, passports, utility bills, driving licenses, etc., we see the original documents, or we are satisfied that there is some form of proof of the original documents. So we're taking photographs, screenshots, etc., of what our client is revealing to us, and we're cross-checking data and information. So if I am your client and I am today on a Zoom call or a Skype call, and I show you my passport or show you my driving license, take a screenshot of that, ask me to scan and email a copy of the driving license or passport across to you, same with utility bills, and then cross-check the data and information that those screenshots, those photographs, that evidence provides. So if I've given you a contact address, is that the same address as my passport and driving license? If I've recently had a driving license or passport issued, ask to see the old one and make sure there is evidence on file that you've utilized the information that you've obtained to verify my ID. Ask questions of a buyer. Why have you instructed our firm? How do you know about us? And make a record. And if, for example, I tell you that I've instructed your firm because you come recommended from my next door neighbor, who is the next door neighbor? And check up that the next door neighbor has in fact recommended your firm. An easy email to the client, the neighbor, thanking them for the recommendation is the easy way of doing that without appearing to be sort of checking or verifying what your prospective buyer client has advised you of. So client identity, essential. Next issue, compliance, transparency with regard to costs, making sure client is aware of the costs, the fees that we will be charging, the expenses that we are incurring, and circumstances where costs may require revision. So the client needs to be aware that these fees or this estimate or this quotation is on the basis of a standard conveyancing transaction, and that there may be issues during the life of the transaction that warrant additional fees on the basis of additional work being required. The obvious thing there being something like a defective title insurance policy. It upsets me, to be honest with you, when firms simply charge the client the cost of the premium. because there is additional work that is required with regard to a defective title insurance policy. There is an aspect of due diligence that are necessary, and of course there's explanation and advice to the client about the existence of the policy that needs to be inbuilt into our systems and processes, and there is a cost implication for that. So as far as costs are concerned, there are a number of cases that I've considered over the years. One in particular, a case called Reynolds against Stone Row Brewer. Not in the notes, but a case that's sort of close to my heart, because in this case, what a judge said was, you can only revise your costs estimate if there's an objectively valid reason to do so. So if the transaction is subject to a quotation or an estimate, and the transaction proceeds normally, you can't charge extra. If there is something unusual within the transaction, then you can charge extra for the work that you do, but there has to be an objectively valid reason for that charge. And you've got to explain to the client the likelihood of an increased charge and give the client choice. So, hey, Mr. Client, do you want to proceed? But there's some additional work that I need to do. It's going to cost you an additional £200 to the fee that I quoted you, or you can withdraw from the transaction if you wish. You can't simply press on, push on with the work, and then tell the client afterwards that there's additional cost. Again, be careful about bolting on costs to try and buy business from prospective or actual buyer clients. As far as transparency is concerned, there is no room at all these days for attracting business on the basis of low fees or low expenses, and then advising the client as the transaction progresses that there are additional fees and additional expenses to be paid for. I mentioned on slide this issue about client objective. I can't emphasize enough how significant this question is in the context of residential conveyancing. So if I'm your client, why am I buying this property? In the past, it wouldn't matter that much, because the purpose of sitting behind the transaction would be the client would be buying this property as their home. These days, we've got buy-to-let clients. We've got clients that are buying a property on the basis that it will be their home, but also their office. We've got clients that are looking at things like Airbnb and the equivalent for generating revenue as a consequence of home ownership. All of those uses, all of those objectives will have issues with regard to our due diligence process, as will the client that tells you that they're intending to construct a swimming pool in the garden. The example there would be, if we're going to be undertaking some digging and construction work, then it may be necessary for a geological search to be undertaken with regard to what mines and minerals are sitting beneath the surface of the target property, where a client advises that they wish to use the property for Airbnb purposes. Are there restrictive covenants that will impact or indeed prevent such a use? Where a client tells you that they want to undertake some development work, build an extension, build a new garage, build a new wing to the property. Well, again, there are issues relevant to the due diligence process that you undertake as a consequence of what you're told about. One of the things I would say in that situation is we've got to quickly latch on to whether the client is expecting any construction or planning advice, in addition to our transactional advice that we're giving the client in connection with the purchase. So client objective is important. The vast majority of resi clients are going to tell you we're buying this as a family home. But again, I would press and push, because there may be other issues, slightly less significant objectives that are relevant, working from home being the most commonplace these days. We need to tell clients the limitations attaching to the due diligence process. We'll talk about that in a moment or two. We're also going to talk about the searches that we undertake. And again, at the very start of this presentation, I think it's important that you are aware that the concept of usual searches does not apply in residential conveyancing. There are searches that are necessary, there are searches that are recommended, all hinging upon type of property, client, location, and client objective. We're also going to talk today about co-ownership, because if we're acting for buyers, more than one, we need to address the issue of co-ownership, and we need to give advice about what is appropriate relating to co-owning a residential property. I'll focus in on these issues in a lot more detail a little later. And of course, we need to explain from the outset funding issues, how the transaction is going to be funded, when funding is going to be required, when monies are going to be required, and what monies are going to be required from the client. I want to talk now about a very important point that, again, I tend to bleat on about, and I often say to myself, surely conveyancers are sick of this topic, but it's so important. And again, I think from looking at what residential conveyancers do and speaking from bitter experience, this is an area that we tend to overlook and fail to advise clients properly about, namely client inspection. Client inspection before exchange of contract as part of the due diligence process is important for 4 reasons. Firstly, our client needs to identify the physical extent of the property that's being acquired. In short, do I know that the garden that I'm wandering around or the drive that I'm looking at is actually within the ownership of the property that I'm acquiring? To that end, client needs to see title plan, needs to see agent's particulars, needs to see description of property within the contract and within the property register if the land is registered. If available, client needs to see survey or valuation. All of this documentation needs to be consistent, all singing from the same hymn sheet, so the client can look at all this documentation and say, I can identify what I'm buying from all of this documentation. Or alternatively, the documentation is inconsistent. The estate agent's particulars refer to half an acre of garden. The surveyor or valuer is saying there's a quarter of an acre of garden. The title plan reveals a rectangular plot, but when I wander around, the garden is triangular. In which case, the client should be reporting back to you the inconsistencies or issues, and then you should be investigating them further. As an aside, I mentioned land registry title plans, and again, important bit of law for you to be aware of. Section 60 Land Registration Act 2002 states that a land registry title plan reveals a general boundary, not a legal boundary, and therefore a land registry title plan is useless in recording the physical extent of the legal title that your client is acquiring. The client needs to be aware of that. Why? A land registry title plan looks like an official document. Why wouldn't I, as a layman, assume that is what I'm buying and that's what I can rely upon? And who wouldn't assume, as a layman, that I can measure out what the title plan appears to reveal and say that's my title? We've got to set realistic expectation in that regard. The next point as to why a client should be told to inspect is to identify the state and condition of the property. The principle of let the buyer beware applies, and the client must inspect the property to check for defects or problems. We need to reinforce the need for the client to inspect for that purpose by advising our client of the need for survey or valuation. Our client should be advised to obtain a level 3 survey and should be advised that in any event they should be paying for the best survey or valuation they can afford. And the client needs to be told that when the survey or valuation comes in, you will read it, looking purely and simply for issues associated with title or due diligence, but the client needs to read it also. So identifying state and condition is important. To also identify overriding interests. And again, here a buyer needs to have spelt out to them by way of example what are overriding interests, point 1. Point 2, they should be told that they need to advise you if there is anything that generates the slightest suspicion that an overriding interest exists. Overriding interests, of course, are interests in land that are not revealed by the title. Would include things like leases with a term of less than 3 years, certain types of easement acquired by prescription or easements of intent or easements of necessity, and persons in occupation. So the buyer needs to be warned what to look out for and advised of the need to report to you. Overriding interest may also be disclosed in the TA forms, but you could have a situation where a seller doesn't appreciate what an overriding interest is and the duty to disclose it. or deliberately conceals it, in which case client inspection is important. Client also needs to inspect to identify information that is generated by the seller within the TA forms and to check their accuracy. Again, a point I frequently labour, the client needs to use the TA forms as a checklist to satisfy themselves as to state and condition of property. Client also needs to be warned that when they're inspecting target property, they are deemed to have knowledge of anything they see. They are deemed to have knowledge of anything that a reasonable inspection would have revealed to them. And they're also deemed to have knowledge of anything that a surveyor, valuer, or any other third party sees on inspection. And the big thing, I think, with regard to client inspection and good due diligence is that the client is made aware that they should be reporting to you anything that they see. I have to tell you from bitter experience that most conveyancers tell the client of the need to inspect. They will, if we're lucky and they're good, tell the client what they should be doing when they're inspecting. But very few go into the detail that I've just suggested to you. But given the fact the client could be bound by an overriding interest that ought to have been revealed on inspection, it is important that we labour that point, and it's also important that we set realistic client expectation with regard to reliance on title plan, and that we arm the client with sufficient information to be able to take a view as to the physical extent of the property or the information the seller is producing in the TA forms. I've touched on survey and valuation, and again, I always refer practitioners to the RICS Consumer Guide to Surveys and Valuations that is available on the RICS website. This is useful in that it does our job for us. We should be always advising our client about the need for survey and valuation. We should be explaining to the client, as I mentioned previously, that they should be obtaining the best survey that they can afford. This consumer guide highlights the vulnerability that is generated as a consequence of simply relying on valuations, and also highlights an important point that if we're getting a level 3 survey, the surveyor should not only be looking at the property, the building, the garden and grounds, but also the vicinity, and highlighting issues that might be pertinent to that vicinity or to our client's purchase. Here I'm thinking of things like rights of way, and appropriateness of rights of way, surface of right of way, etc., and other issues in the vicinity that may impact on valuation or client's wish to purchase the property. So a level 3 survey, if you look at the RICS Consumer Guide, is going to afford the client far greater protection than anything else. With regard to a lender's valuation, if our client is simply relying on that, the client needs to be aware that the valuer is in essence determining whether or not the property is sufficient security for the amount of loan that the lender is generating, and nothing more than that, and therefore is of extremely limited value to our client. Where a survey, or indeed anything else generated by due diligence, warrants further investigation, the client needs to be told of that fact and needs to be advised as to what specialist reports may be appropriate. So the surveyor reveals that there's a damp issue with regard to the property, or a roofing issue with regard to the property, or an issue with regard to tree root damage to foundations. Then the client needs to be pointed in the appropriate direction for specialist advice. Where we're not sure what that specialist advice is appropriate, so is it a surveyor, is it a damp-proof specialist, what are we talking, or is it an engineer, what are we talking about? The surveyor or valuer that has highlighted the problem or identified the problem should be asked what sort of reports and information should be sought by the client. And again, deal with the basics, do the simple things well. Our client is buying probably the major investment of their lifetime, and therefore they need to be cautious and careful and aware that they buy the property with all its foibles, with all its defects, with all its problems and issues, and that it is difficult, if not impossible, for a buyer client to seek redress from a seller after the purchase has taken place. We recall from our last conversation that the seller produces a contract bundle, draft contract in duplicate, official copies of the register, the 3 registers, title plan, and any documents referred to therein. TA forms TA6 and TA10 in a freehold purchase, guarantees and ancillary documents in an EPC. As we'll see in a moment or two, as part of due diligence, a buyer's conveyancer is obliged to investigate and consider and scrutinise all the documentation that is produced. Again, it is not enough simply to provide our buyer client with copies of the documents. It is essential that our client has explained to him or her the significance of the documents, their use in the conveyancing process, and key features of them. So I can't just give my client official copies of the register and say, read that. I've got to refer to the charges register and the property register and extract from those registers information that's relevant to the client. And when we talk about information that's relevant to the client, we're going to produce a report on title. The report on title might be one full document at the end of the due diligence process, or it may be a series of interim reports on title as and when processes during the due diligence process have been completed. So we've got the contract bundle. We might provide our client with interim report number 1. We've got our searches back, or we've got our mortgage offer back and survey, so there may be interim report number 2. Searches may be delayed, etc., and therefore they're incorporated into interim report number 3. We may then produce a final report and summary, or we may simply wait and produce a final report on title when all the due diligence exercises have been properly completed. The important point is I cannot simply give my client a copy of the contract and say read it, or a copy of the official copies of the register, or email or attach them in an email to the client and say read it. There has to be a degree of explanation. There has to be a degree of advice relating to documentation and the process. One of the things that's quite interesting on looking at a report from a professional indemnity insurer is the fact that they were getting worried that conveyancers are simply following procedure and acting as a mailbox. And what they're saying is you can't do that. You've got to explain, you've got to advise the client on the basis that the client may not understand the significance of these standard conditions in a contract or the existence of easements or restrictive covenants in a registered title. So there has to be an explanation as to what these are and how they impact on the client, and perhaps how they may impact on subsequent buyers of the property, subsequent lenders of the property too. Of course, things that are discovered during due diligence may also have an impact on valuation, which the client should be aware of, and of course, which our lender client should be aware of as well. So, official copies of the register, what we should be looking at is the type of title, freehold or leasehold, quality of title, ideally an absolute title, issues such as the existence of easements that are for the benefit of the property or which the property is subject to, restrictive covenants that are protective of the property or which burden the property, and other rights or interests that are disclosed by the title. Remember that our report on title should also incorporate any overriding interests that are revealed or disclosed to us courtesy of client inspection or revealed in the TA forms by the seller. Official copies of the register, therefore, relatively simple exercise to consider. Nonetheless, we need to consider them. I've dealt with so many negligence claims where a conveyancer has looked at a title and thought, yeah, I've seen this title before, I know everything that's in it, I'll just scan it and make sure everything's fine. And then at a later date, we find something weird and wonderful in the property register that means this title is not good and marketable. Dealing with a matter last week where someone had acted for a client, saw that the title was a possessory title and sort of dismissed it and advised the client not to proceed. The possessory title had been acquired by adverse possession. The adverse possessor had been in occupation for the property, and the possessory title had been registered for a period in excess of 12 years, meaning that it was possible to upgrade the title to an absolute title. The seller's conveyancer, when the buyer's conveyancer advised that the client was withdrawing from the transaction, highlighted the fact that this title could be upgraded. But the buyer's conveyancer was entrenched and decided that that was it. The client should be advised not to proceed, and therefore the transaction failed. Again, important to check the title in every circumstance, and if there are defects or problems, consider whether or not those problems can be resolved, or where they can't be resolved or can't be resolved satisfactorily, then to look at a defective title insurance policy. And again, Robert, if you could join me for a moment or two, thanks for listening in today. Again, I think it's important that practitioners are aware of the facility that Stewart Title offer. In that, one, there is the comfort and availability of online policies. And in addition to that, where something is unusual or where you've got cumulative defects in title, I know that your underwriters and your team are happy to help to provide bespoke policies. So Robert, if you could just share for a moment or two with me and listeners and people that are viewing this webinar, I think that's fair, isn't it? You've got this magic fix of convenience of online for sort of standard stuff, and you've got expertise and facility, back office facility, to deal with more complex stuff that may arise in a sort of fairly standard conveyancing process.
Yeah, that's exactly right. Not all problems that arise fit into the neat boxes of an online system. Majority do, and the great thing about the online system is you can select and order a policy in literally less than 90 seconds and have a draft policy there to go to the other side, get it approved. But where you can't fit into those criteria, if you've started online, it automatically goes through to our underwriting team, who will then produce a bespoke policy for you, taking into account your circumstances, or you can approach directly and ask for that at the outset. So it does give you the facility to see there, and because it is quick and easy, it gives you the chance to see if a policy is what you need in those circumstances and is going to protect your client's needs.
Yeah, thanks for that, Robert. I think the other interesting thing about that, Robert, is that there's a resource there, isn't there, for your clients and customers, so you can get a second opinion or review. So if it is a bespoke policy or an unusual set of circumstances that the conveyancer has encountered, you can use Stewart Title and your staff and your expertise as a sounding board to see, you know, is this the right way? Is this the right approach? What should I be doing to try and identify what the problem is so that your underwriters can create this bespoke policy?
Yeah, I'm sure my underwriting colleagues wouldn't thank me for saying it, but yes, I think it is a useful resource for conveyancers. Conveyancers, as you and I were, we see the world in certain ways, insurers don't. And the great thing, the knowledge of our underwriters is they see problems every day. They don't see the transactions that proceed normally. So they're always dealing with these problems. Even if it's new to you, almost certainly they would have seen it, or someone in the firm would have seen it before. So it is there, a knowledge bank you can draw on. Thanks
for that, Robert. It's very important to understand this sort of two-way approach with regard to defective title insurers and Stewart Title in particular, in the fact that, you know, they have experienced underwriters and experienced members of staff such as Robert that are there to help, as well as having the immediacy and of the sort of online product and online assistance. So going back to the point that we first explored in webinar number 1, a buyer's conveyancer should be taking out a policy even though the seller has a defect in title, and the seller should be paying the premium. The buyer should be advising the insurer about the policy and making investigations relating to it, so the buyer has control as to the type of policy and what information is provided to the insurer. So there's control over that. I think that's significant. On slide, I mentioned TA forms, and TA 6 and TA 10, two issues. The seller's inquiries before contract that are pre-populated, so that are provided in standard form, courtesy of the conveyancing protocol, are completed by the seller without legal advice. The seller potentially could be vulnerable to a misrepresentation claim if any of the replies are defective. But I would always maintain, from a buyer's perspective, when acting or representing a buyer, we should be telling the buyer to use the TA forms as a checklist. So central heating system, Mr. Buyer, when you go to the property, ask the seller to put the central heating system on and check that it works satisfactorily. If the seller is telling us that there aren't disputes with neighbours, then it's worthwhile when you're going to view the property to have a chat with the neighbours if they're out and about and just see if what they're saying is true or not. Just being wise and just sort of cross-checking information is appropriate from a buyer's perspective. From a conveyancer's advice perspective, we should be telling the client that there is a danger in relying solely on the information the seller generates in the TA forms. Because although the seller may be deliberately lying or may be misinformed, and we may have rights of address as a consequence, the reality will be we're not, as conveyancers, buying litigation for our clients, we're buying property. We don't want to have to get redress and to recover loss by way of court proceedings. That's not our game, and our client, even if ultimately they're successful with regard to litigation that they embark upon, are not going to be happy that they've had to do that in order to seek redress or to get what they were trying to get in any event as part of the conveyancing transaction. If the TA6 forms and the replies to inquiries before contract generate or require further investigation, the client needs to be made aware of that fact. So if the seller is telling us there's a problem with the central heating system and there's a problem with the boiler and a report's been obtained from a heating engineer, then we need to call on that report, provide it to the client and tell them that appropriate advice needs to be obtained or estimates obtained with regard to the work that's recommended by the report. With regard to TA10, fixtures, fittings and contents form, again, client should have explained to him or her the significance of this, that reveals what the seller is including in the sale or taking from the property that should be included in the sale, and we need to make sure that our client is happy with that. Where the seller is leaving white goods, if we're paying for white goods, we need to make sure that those goods are working. Where there is a price being paid for chattels or contents, it is important that if the price is to be apportioned, saving SDLT for our buyer client, that there is independent evidence to verify that the apportionment is fair and reasonable. Our client needs to be advised in the appropriate circumstances where a price is being paid for chattels and that leads to an SDLT reduction. The client needs to be aware that if the situation is that the reduction in SDLT liability arises due to fraud, then our client commits a criminal offence, and that the HMRC are entitled to investigate conveyancing transactions to ensure that the correct SDLT has been paid. With regard to guarantees and ancillary documents, we need to make sure that the client sees that documentation and again is aware of the fact that specialist advice might be required to ensure that the guarantees are in fact enforceable, or whether work is required that could be covered by such guarantees. Same thing applies with regard to the EPC. As a residential conveyancer, before I leave this slide, there isn't an expectation that we are knowledgeable about plumbing, knowledgeable about electrical systems, knowledgeable about other items within the property. Our job as transactional property lawyers is to highlight issues that are revealed by due diligence and then recommend to the client the fact that the client needs specialist advice or appropriate advice with regard to issues that we find. As far as the TA forms are concerned, as I explained, these are standard forms, and that an incorrect reply could lead to misrepresentation, although misrepresentation actions due to defective replies in connection with TA forms are rare. And it's quite difficult to call whether such a claim is going to be successful or not. There are a lot of variables and a lot of difficulties with regard to misrepresentation actions. So if you're just simply saying to me as a client, if the seller has lied, if the seller has provided a defective response, we can sue for misrepresentation, that in part is correct, but isn't the complete picture. The client needs to be aware of litigation risk, litigation cost, and problems associated with delays in our court systems. We need to be careful where sellers give what I class as legalistic replies, not so far as the seller is aware. buyer must in all respects rely on their own inspection and survey. Such responses are not going to protect a seller necessarily, and in some circumstances generate greater risk of liability for a seller. So where a seller has produced what I would class as a legalistic response, we need to explain to our client the significance of that response, what the seller has attempted to do, and what the legal reality is with regard to that attempt. I've given you some case law which highlights that sellers can't disclaim liability for misrepresentation. They can't limit or apportion risk with regard to liability in the same way that a commercial client could do with regard to replies to commercial inquiries. An innocent misrepresentation could lead to a contract being avoided on the basis of common mistake. There may also be opportunities to rescind where there is fraudulent misrepresentation or misrepresentation that is so extensive it means that the buyer is acquiring something radically different from that which he or she thought they were buying. Before I leave this slide, there are some other points that I want to make with regard to inquiries before contract. The conveyancing protocol highlights and emphasizes that a buyer should not be raising additional inquiries. The whole purpose of the conveyancing protocol is standardization of procedure and documentation, and to that end, TA forms have to be utilized. But there may be circumstances where additional inquiries are appropriate. Point number one, you can't just raise a general additional inquiry. You can't undertake a fishing exercise. But the transaction, the client objective, other data or information that's been received by the buyer's conveyancer may warrant additional inquiries before contract. And that's perfectly acceptable. So, as we talked about last week, where we have a situation where we've got an existing defective title insurance policy, we might put special conditions in the contract relating to the existence of that policy and seek warranties from the seller as to premium being paid, lack of awareness of any issues that would invalidate the policy, etc., etc. So it is possible to insert additional special conditions in the contract. It is possible to raise additional inquiries, notwithstanding TA forms. But both with regard to special conditions in the contract, additional inquiries, these can't be just sort of inserted as normal, as part of our standard conveyancing process. There must be specific reasons for their use. But we can ask additional inquiries. I would ask my buyer client at the start of the conveyancing process whether there are any additional inquiries that they would like me to generate and ask the seller of. The contract incorporates standard conditions of sale 5th edition in tiny print. As I've emphasized already, we shouldn't be providing the client with a copy of the contract and asking them to read it. We should be highlighting to the client key features of the contract, namely latest time for completion, buyer's obligation to insure on exchange of contract, seller's obligation to provide vacant possession. But beyond that, we are going to not have sufficient time, and the client's not going to have sufficient interest to go through each and every standard condition. But we should nonetheless be telling the client that they are bound by each and every term or provision within the contract. Things like purchase price, encumbrances, deposit, contractual interest rate should be explained to the client, and the significance of those provisions explained. Particularly interest rate, on the basis that client buyer needs to be aware of the penalty that faces them in the event of buyer default at completion. As far as the deposit is concerned, the client needs to be advised as to the norm that a 10% deposit is paid on exchange. All conveyancers deal with that point. Not many conveyancers explain to buyer clients that where they're paying a reduced deposit, if they default at completion, the balance of the deposit becomes immediately payable. Nor do they explain to the seller client the same principle, meaning the seller potentially will have to sue the defaulting buyer to get the remainder of the deposit from them. When we are advising our buyer client in our report on title, we may well be including the contract and asking the client to sign it. The client needs to be aware of the significance of signing the contract and what we do with it, namely the exchange process and the fact that the buyer client will be bound on exchange. The buyer client also needs to be aware of the fact that we will not exchange contracts on the client's behalf unless and until it is safe to do so, unless and until we've got client's authority to exchange, and unless until we're satisfied that the requirements of the lender, where appropriate, are met. We also need to ensure that, as far as the client is concerned, they understand and appreciate that we can't exchange contracts until we've got a satisfactory mortgage offer, if that's still awaited, or survey and valuation has been returned to us. That might be awaited, and that may cause a delay with regard to exchange. And of course, where we've got the need to synchronize a dependent sale, the client needs to be made aware of that fact, or client confirming to us that they're happy to proceed without a synchronized sale transaction. I mentioned on slide the issue about dealing with variations to the contract, and this is an important practical point. Quite frequently in the conveyancing process, we've approved the contract and sent it back to the seller's conveyancer. We've sent our part contract to our client for signature, the client has signed it, and then it's back on our file. And surprise, surprise, we're going to exchange contracts this afternoon, and the seller says we need to insert a special condition in the contract. Client buyers agreed to buy some carpets for an additional £500. We've agreed that instead of completing at 2 p.m, we're going to complete at 12 p.m, or sorry, 12 noon, because we've got a dependent purchase that we need to complete on. Could be lots of variations that are announced right at the 11th hour. How do we deal with them? In an ideal world, contract redrafted, contract sent out to client, contract re-executed, back on our file. Chances of that happening if we're exchanging this afternoon and it's 12 o'clock today, slim. So what can we do? What I would do is always agree a variation to the contract and ideally get an exchange of emails with the variation wording, and then handwrite the variation to this contract, insert the appropriate special condition. Then scan it, email it to my client, and ask my client to approve it. If I can't do that, then I need to speak to my client, tell the client how the contract has been varied, explain the wording that's been used, and ask for their client's authority to proceed on the basis of that variation. Now, again, in the heat of battle, that can be a difficult task, but it's important because what I'm worried about is the client, my having exchanged contracts, turning around and saying, I didn't agree to that. I wasn't aware of it. Only now when I read it do I see what that provision actually means and the additional payment that the seller is entitled to as a consequence. So be careful. Important point here. If we are handwriting variations to a contract and our handwriting, what we write is not the same, so we have a conversation, we agree a new special condition, I handwrite the new special condition in the contract, you do likewise, but we've misheard one another or not recalled what was said, and our varied clause is not the same, and we then exchange, technically that clause would be unenforceable. Because Section 2 of the Law, Property and Miscellaneous Provisions Act 1989 require the contract to be the same. So if the contract is varied, the variation must be the same. Where we're annexing documents to the contract, the TA10 form, for example, or a transfer or a plan, the plan, transfer, or other documentation must be the same in order for there to be a valid exchange. Absolutely essential that variations to the contract are dealt with carefully. There is a danger that we think, well, it doesn't really matter, and let's just get on with it and get the thing exchanged. We've got to get client's authority and client's approval to the variation. In an ideal world, I would want my handwritten special condition initialed by the client or the contract re-signed. The reality will be that will be impossible. I want to talk now for a little while about searches. And the first thing I want to talk about are local searches, local land charges searches that reveal local land charges. Things like compulsory purchase orders, enforcement notices, smoke control orders, etc. These are significant because they're overriding interest. They are binding on the buyer at completion, and therefore if there are local land charges in situ, our client is subject to them. Our client needs to be aware of what a local search does and also what it doesn't do. A local search and additional inquiries of local authority are out of date the moment they're done. Local land charges are the responsibility of the local authority, although local land charges are migrating to the land registry. All 360 local authorities or thereabouts are required to migrate local land charges to the land registry over the next 3 years or so. Local land charges searches that are managed by the land registry have a number of advantages. Notably, the search result, the official search result, can be back within 24 hours, and it's possible to do an online search instantaneously. Further, if a local land charges search is undertaken at the land registry allow the local land charges search to be revised, reviewed, or a new search undertaken within 6 months. So it means we can constantly update our local land charges search if there is a delay in the conveyancing process. Additional inquiries of the local authority remain the responsibility of the local authority. There's no plan as yet for additional inquiries to be transmitted to the land registry in the same manner. So local land charges search done, search result back, adverse entries reported to the client. Local search done and delay, then client advised of delay. We can't exchange if we're acting on behalf of buyer and lender without a clear or completed local land charges search, unless our lender and our client are satisfied with an indemnity policy. And again, Robert, if you could just assist in this regard, there are policies that are available, aren't there, in connection with delayed searches. Could you just shed a little bit of light in your experience with regard to the use of such searches? Is it quite a common search that practitioners are utilising?
It's probably not used as much as it could be, but yes, there are search delay policies there. So where you've submitted searches and some or all of them are not back yet, and that's often the case, is that you've got a number of them back, but some are still outstanding, then search delay policy does protect you against anything which has not been revealed so far. So it is a useful policy to get. It obviously, you can get it to protect the client and the lender, but if it's a case where you're trying to protect the lender, then you can get a policy there to do that. We have honed those and changed them in the last couple of years with instances like the Hackney hack. We have been able to choose policies that merely refer to the information that's not available. And back at the start of lockdown, some of the water authorities had problems in supplying information. So we're able to fashion a search delay policy there, which acknowledged you had 90% of information back, but that we would cover the 10% you haven't got back yet.
Right. So Robert, is that a product that will cover all searches? So I don't have to specify that I'm waiting for a search, it will cover all of them, or do I specify that I'm still waiting for a local search and I need a policy for it?
Most of our search policies actually cover all of the standard ones: drainage and water, mines and minerals, and local land charges and local authority search parts. Some practitioners don't like it covering everything where they've got some of the information back. They think that's confusing. So in that case, we can change it to take out the ones where you have the information. But on its own, it would cover all standard searches.
That's great. And that's available online, or I have to speak to someone in your office about
online
it? Or...
policy, again, self-issue for you there. So 90 seconds start to finish. So it's certainly something to think about if you're coming up against the deadline and you can't get any joy from the search provider.
Brilliant. That's great. Thanks for that, Robert. Thank you very much. As I mentioned already, with regard to setting realistic client expectation, we've got to be careful. Local land charges searches are sometimes defective. Local land charges, searches, additional inquiries, and other searches can be outdated. Things can happen. And if you are aware of it via a disclosure by the seller or by your client telling you, hey, I think there's a planning application gone in adjoining some land next door or whatever, then you need to be alive to the fact that it may be necessary to refresh or update the search to ensure the client is kept fully informed. With regard to replies to inquiries of local authorities, the key here are things relating to roads and footpaths, planning matters, contaminated land, etc. And again, client needs to have the results related to them. The provision of the search and saying, read that is not enough. We need to be highlighting adverse entries, reporting to the client the significance of a smoke control order, or the fact that there's an issue relating to contaminated land, or an enforcement notice being served relating to planning matters. And again, case law highlights the fact that you're not expected to be a planning expert or an expert on contaminated land. You are expected simply to advise the client that additional work or specialist advice is required in that area. Water searches and drainage searches are of course important to make sure that our property is connected to public water supplies and that sewage, etc., are connected to mains, drains and sewers. Where there are private water supplies, again, caution needs to be exercised in that there needs perhaps to be specialist reports obtained with regard to water quality, pipe work, and of course the appropriate easements and rights relating to repair and maintenance of water pipes would be appropriate. As far as drainage and water searches are concerned, they may also reveal issues relating to flooding. Again, if anything is revealed that looks unusual or refers to something that will have implications for your client's acquisition, and specialist reports can be obtained, at the very least, the client needs to be warned about the issues. If we have a valuer or surveyor acting for our client, again, issues with regard to private water supplies, etc., may impact on the advice that they're giving and may also impact on valuation too. I always recommend that where a client is buying any property, commercial or residential, rural or urban, freehold or leasehold, that the conveyancer advises the client of the need and benefit for an environmental search. Some lenders will insist on an environmental search, others leave it to the discretion of the conveyancer. But given the amount of contaminated land that there is in England and Wales, given the potential vulnerability for decontamination cost and cleanup cost that a buyer, tenant or occupant can be liable for, an environmental search and report should be obtained. Search gives you historical land use. Report will give you risk analysis. You need both. Client needs to be aware of the content of the report. You need to be careful as a transactional property lawyer to ensure that your client understands that you can't give advice about contamination issues, and that here you are, in essence, a mailbox advising the client to read the report and seek specialist advice relating to it. On new builds, do watch, because sometimes builders or developers will have had an environmental search and report that appears to be very extensive, undertaken when the property was acquired, when the development was acquired, and they will pass on that to people that are buying houses or plots on the development. Environmental searches and reports and the quality of the same have changed and altered over the years. So you might have had a report 4 or 5 years ago that reveals the site is clean, and you might engage a surveyor to produce a report today, and the same piece of land would reveal to the surveyor or the expert that the land is in fact contaminated. Environmental searches and reports have moved on over the years, and therefore historic reports may not be as reliable as you'd first of all think. And in addition to that, the other point is that contamination can migrate onto a site, causing contamination that didn't exist in the past. There are a raft of other searches that may be appropriate, and we're fortunate in that today our search provider can tell us the searches that are available. There are certain searches, as Robert alluded to, that are essential searches: drainage and water, local search and additional inquiries of local authority, environmental search. There may be searches that are property specific, coal mining searches, tin mining searches, etc. there are other searches that you may not think would be appropriate, pre-contract searches that may be necessary. Here I'm thinking like about a sim search. If I'm buying a property that has 2 or more registered titles that comprise the plot or the property, I might do a sim search of the site to make sure that those registered titles abut one another. If I've got an issue with regard to a boundary problem or an inability to identify a boundary, a sim search of the boundary might assist me with regard to boundary identification. And of course, sim searches would be appropriate where we're acquiring unregistered land. But sim searches have their benefit and their use when there are complex registered titles being acquired. If insolvency is an issue, if the seller is in financial difficulty, then do think about bankruptcy searches. If we're buying from a limited company and there's an issue about that company being in administration or subject to a CVA, then again, a company search may be appropriate. And of course, these days, when we're exchanging contracts and potentially completing simultaneously, then we need to think about our pre-completion land registry searches, which again may be appropriate if there's an issue or problem with regard to the title or recent entries referred to or disclosed to us by the seller. It may be appropriate to do a land registry search early on to see just whether or not what those adverse entries are and what they relate to. So in short, what I'm saying is do think about the bigger picture with regard to status of seller and status of transaction. Co-ownership is a problem when acting for a buyer. In the notes, I've given you extensive details about co-ownership, but in short, I can explain a number of points quite quickly. One, it is imperative that when we're acting for more than one buyer of a property, we do not assume that we can act for a collective client. There's no such thing as a collective client. Point number two, where we are acting on behalf of co-owners, it is imperative that we get as much information from co-owners in order to give advice to those co-owners. To that end, I always recommend the use of a co-ownership questionnaire. That co-ownership questionnaire will ask the clients what their actual contributions are and what their wishes are with regard to how the property is held. In particular, it will specify that we can provide for how the beneficial interest is held, and that beneficial interest can be representative of client contributions. Should also explain that the property can be held as joint tenants where the doctrine of survivorship applies, or they can hold as tenants in common where the beneficial interest can be divided however the clients wish. If the clients own as joint tenants, then the clients own on a 50-50 basis. We need to know about clients' intentions. So are they likely to be spending money on the property? And if so, are they going to be spending that money in the same proportions as their purchase? In which case, they may be contributing 50-50 to the initial purchase price, but then one of the parties might be getting a redundancy or an inheritance at some time in the near future and spending £80,000 to £100,000 on home improvements, extensions and alterations, which might skew the beneficial interest and require a tenancy in common and a deed of trust to be varied or altered. I've given you some case law that highlights the fact that we've got to explain to the client's choice and the significance of choice, namely this case of Turner against Bromwich Jackson's Heath LLP. Solicitors in this case escaped a negligence claim because they had properly and fully explained to the client's choice and the significance of holding as tenancy in common or holding as joint tenants. So although the client that brought the claim was bleating that they hadn't had a full explanation as to the choices that were available to them, and argued that unequal contributions automatically led to a risk of conflict of interest, the lawyers were able to bat off the claim on the basis that the clients had a full explanation as to the concept of a tenancy in common, full explanation as to what the declaration of trust was doing, and the client was fully aware of their position. Significantly, and again, this is a point I like to emphasize, the lawyers had not just provided the client with information, but extracted from the client that they understood the information that had been produced. This is the point that I make about effective communication. Effective communication is not bombarding a client with data or information or sending the client an 80-page report on title. It is doing that, if you must, but then ensuring that the client has read it and understood it and doesn't have any questions. Bromett Jackson Heath LLP were completely exonerated in this action as a consequence of doing the right thing and making sure the client was informed and making sure that was evidence on file that the client had been informed, perhaps is the more important point. Oxley and Hiscock confirms that we should be inquiring about sources of funds and ensuring that we've got sufficient information extracted from our clients to be able to give meaningful advice. In connection with giving advice, I emphasize choice. Clients should have the choices available to them. Joint tenancy, 50-50 split, but the benefit of survivorship. Tenancy in common, whatever split or distribution we want, no survivorship. We can't assume that joint tenancies are always appropriate where clients are in a stable relationship and where there's equal contribution, nor can we assume that a tenancy in common is appropriate where there's a business or commercial relationship and inequality of contribution. We offer client choice, we look at clients' circumstances, and then we give advice. Practical problems, we've got to explain in layman's terms to clients the significance of a joint tenancy and the doctrine of survivorship. The fact that if you have a will in which you leave everything to the dog's home, it matters not if you own a property as joint tenants, survivorship triggers on death before the will, and the property, the half share, goes to the surviving joint tenant and dog's home loses out. We also need to think and advise clients as to what happens if a party wants to sell and what happens if a deed of trust created in connection with a tenancy in common requires alteration. There's an expense and some legal involvement required. We should also explain to clients that we can use Land Registry Form JO to explain how beneficial interest is held, etc. But where we're dealing with tenancies in common, a deed of trust is the better way of dealing with things, but there is a cost consequence. I talk about considerations for clients. Clients should have choice. Clients should be aware of the considerations that are taken into account with regard to choice. Clients need to be told about the doomsday scenario if there's a falling out and what the consequences of that falling out will be given the choice that has been made relating to co-ownership. And clients need to be told about the need for advice in the future if circumstances change. If our clients are proceeding with a joint tenancy and the doctrine of survivorship is to apply, clients need to know and understand that the joint tenancy can be severed, creating a tenancy in common in equal shares. So just because I create a joint tenancy at the start, that would not preclude either party unilaterally severing it and creating a tenancy in common. There's been some case law with regard to that. With tenancies in common, clients need to know that survivorship does not apply, that the client needs a will, that the client needs to understand that they can't change a tenancy in common in any easy and quick way into a joint tenancy, and that a deed of trust is going to need to be reviewed and updated fairly frequently, and there is a cost implication in that and a cost implication in connection with the preparation of a deed of trust in the first place. I mentioned in the notes an insignificant point, again, which I deal with on slide. What happens if a TR1 is not signed by the buyers? Where you're dealing with co-ownership, it is imperative that the transfer is signed. In most conveyancing transactions, unless there is some form of covenant being given by a buyer, it's not necessary for the buyer to sign the transfer. But given the fact the transfer will contain details as to whether or not the parties are holding as co-owners as joint tenant or tenancies or tenant in common, it is necessary where co-ownership exists for the buyer clients to sign the transfer. Quite a bit of case law on that, where the courts have had an interesting exercise in determining whether or not a wrongly completed transfer was binding on the parties, or what the status of co-ownership was where the transfer was silent or where the parties hadn't signed the transfer. There isn't a sort of conclusion from the case law. In short, each case turns on its own facts and merits. The last thing I want to talk about today is funding. And when we're acting for a buyer, there are a number of issues. Firstly, the start of the transaction, the client needs to be aware of the cost of the conveyancing process and the outlay that's going to be imposed upon them as the process progresses. So things like transparency with regard to fees, costs and expenses, the fact that a deposit is going to be required in exchange of contract, potentially 10%, the fact that that deposit could be lost in the event of buyer default, advice given with regard to mortgage and requirement for satisfactory mortgage offer before proceeding to exchange of contract, making sure that client understands the significance of the mortgage offer and the security that the lender will require, and the possibility that that security will be relied upon in the event of buyer default in connection with mortgage payments. Buyer client needs to be aware of the fact that SDLT and land registry fees will be payable post completion, but that funding will be required to facilitate completion. All of these things need explaining at the start and need to be included within the report on Title 2. So when acting for a buyer, it is important that we are comfortable with the client's awareness and understanding of the financial implications of the transaction. As lawyers, we've got to be careful to make sure that we are satisfied as to the source of funds, where our client is utilizing his or her own funds to facilitate purchase, because of course we've got to be on guard to the potential for money laundering. All of these issues we'll explore a little more as we progress in this series of webinars. But the 10 good habits that I want you to extract from today are the point I've just mentioned: be alive to property fraud in all its guises. Identify client objective and tailor due diligence, tailor reporting to client in that connection. Set realistic client expectations. Make sure our client has the conveyancing process explained to them, and explained that as we undergo the process, what the process reveals. So the client understands the mechanisms, the processes, the commitments, duties and obligations that arise within the conveyancing process. And as I explained with regard to some of the case law a little earlier, make sure we're communicating effectively. Explain the limitations of searches. Make sure the client understands the significance of inspection. Explain the significance and the need for survey. Explain what defective title insurance does, and explain to the client their duties and obligations relating to that insurance. And in short, do the simple things well. On behalf of Stewart Title and indeed myself at IQ Legal Trading, thank you very much indeed for attending today. Hope it's been of some interest and use. If you have any questions or queries arising from anything that I've said or not said, or you want clarification of any points that I've made, please feel free to drop me a note and I'll endeavour to assist. But on behalf of myself and Stewart Title, thank you very much indeed for listening and watching today, and for your time and attention. On that happy note, thank you very much and goodbye.